Hello, welcome to this morning to this short session. We're going to talk about in the civil code, there's a term under the section transferring without the aid of a broker. It's one of your sections in civil code. We're going to specifically talk about donation inter vivos. Donation inter vivos. One of two different types of donations in the civil code when it comes to property. My name is John Enzing. I'm a certified real estate instructor, and I'm licensed both in Louisiana and Florida. My specialty is to tutor you, the student, to prep you for the state exam. If you need some private tutoring, go to privateturingsession.com. That's privateturingsession.com, or you can email me at john.enzing@gmail.com. All right, let's go ahead and dive into this. Here we go. Donations. Remember, this comes out of your section in the civil code of the state portion, transferring without the aid of a broker. What does that mean, John? Transferring without the aid of a broker. That means you don't need a real estate licensee. You don't need a broker to help transfer property, okay? So people can donate property at any time. And this is what we're going to talk about today. So when it comes to donations, again, as mentioned earlier, in the addition of transferring by sale, which is the normal way we do business and the normal way that we use brokers and real estate agents is to sell property. But property can also be transferred by donations, even successions. When someone dies, property is transferred. Annexation or willfully gained through prescription. Remember that term prescription is the same meaning in common law, the term adverse possession, which means they take on the property due to the fact they occupied it, again, without the owner's permission. So prescription is that civil code term that matches adverse possession in common law. And there's other operations of law that people can transfer property. But we're going to specifically talk about donations in this session. Now, there's two types of donations. The first one we're going to look at is inter vivos, donation inter vivos. And then you got donation mortis causa, okay, which means of death. But we're going to talk about inter vivos in this session. So what does it mean? Well, just what it means, donation while the donor is alive. Remember, in a donation, you got a donor and donee, okay? Just like in an offer, you got an offer or offeree. In a mortgage, you got a mortgage or mortgagee. In a lease, a lessor or lessee. So a donation, you have a donor, that's the one that's donating the property, to a donee, the one that's receiving the property. So when we talk about inter vivos donation, we're talking about the donor is still alive and they're going to donate the property. There are three types we're going to look at. The first one is gratuitous. And you want to know this for the state exam. Gratuitous is a donation, but the donor is not looking for anything in return. Okay. In other words, they're donating without any conditions whatsoever. They're just donating the property. Okay. So nothing in return. Remember, no conditions applied to the donations. That's gratuitous. It's almost like a gratuity that you leave when you go out to eat for the wait staff. The next one is onerous. This is a donation, but now it's burdened with charges, okay, imposed to the donee. In other words, the donee is restricted to only perform certain functions within that property. Much like the common law, fee simple defeasible. Remember, the ownership is indicative of operating that property and ownership specifically under the order of the person that sold them. Same thing with the onerous donation. For example, if I donate you a property, a building, and say, here's the charges upon this as a donee, you can only operate this building as a function of doing this only. If you do anything else outside of the instructions of the donation, you could lose the donation and it reverts back to the donor. Okay, so onerous is burdened with charges and certain specifications imposed upon the donee that they have to perform. Remunerative. Now, this is donations that are made and they're rendered, services that are already rendered by the donee. Okay, so the donee has already performed some type of service, and then the donation is given to the donee. Okay. Now, a few special facts we want to learn about when it comes to donation inter vivos. It can have reservation of usufruct. You remember, I got a tutorial out there talking about usufruct, the right to have uses and enjoy the fruits of it, usufruct. Remember, the donor may reserve the right of usufruct. In other words, if I donate you property, I can reserve the right of usufruct and stay in the property, use it, enjoy the fruits of it until death. Okay, so the donor can reserve the rights of usufruct of the property. The property is still donated to the donee, but the donor is going to stay in the property under usufruct rights. Now, a donation has got to be made through an authentic act. You remember in the Civil Code, an authentic act is it's got to be notarized. You got to have 2 witnesses, and if the person's blind, you got to have 3 witnesses. Okay, so it's got to be an authentic act for the donation. And then revocation. Again, this is non-fulfillment. Could be from ingratitude or any other type of means. Okay, revocation means it goes back to the donor. Okay, so they're not fulfilled the terms of the transaction of the donation. It can revert back to the donor. Hey, listen, I hope you enjoyed this short session when it comes to donation inter vivos while alive. Gratuitous, onerous, and remunerative are your 3 types. Okay, listen, if you need private tutoring, go to privateturingsession.com, privateturingsession.com. Good luck on your exam. Bye for now.